Well, good afternoon, ladies and gentlemen. Here I am in Kiev airport, of all places, having had my flight back to Warsaw overbooked, so I've had to suck it up, basically, and get a transfer from... I've got to fly all the way to Munich before I then fly back to Warsaw tonight, what should be a 90-minute aeroplane journey. So, anyway, my principle of flying around Eastern Europe is not to get annoyed, but to try and capitalise on the dead time by doing things such as producing a vlog. Now, this is a vlog that I've taken great pains to prepare, and I think that this, if you are contemplating litigation, if you are somebody who is faced potentially, and I will come on to some examples in just a moment, with really quite serious litigation, perhaps in respect of a property, and perhaps someone's not paying you your rightful share of that property, and you feel aggrieved, and you've perhaps exhausted all other routes, including the route of an hourly paid solicitor who may be very good, maybe your high street solicitor, your regular solicitor, but unfortunately, as is the case with a lot of law firms, they don't do no win, no fee. And unfortunately, as is the way of the world, your opponent, who may be richer than you, who may actually be occupying the property, it knows this and will do all he can to create barriers and obstacles in your path to obtaining your rightful share of the equity in that property. Now, although I am talking primarily, or the examples that I'm using are cohabitation, property litigation generally. I've been specialising in doing a lot of cohabitation property disputes recently. That's why these are the examples. This has got broader application to anybody who's contemplating instructing a lawyer in a no-win, no-fee deal. Okay, outside personal injury. Okay, outside personal injury. Before I come on to the meat of the vlog and three key areas that I think you need to be aware of in respect of hidden costs, because as the title of the vlog kind of reveals, what really is the cost of instructing a solicitor on a no-win, no-fee deal. I will cover those three key areas of cost that may be somewhat hidden when you commence instructing such a solicitor, before coming on to conclude. But before I do get into the meat of the topic, I want to do a bit of a plug for my own law firm. Why not? I have today got an email, which unfortunately lack of access to the airport Wi-Fi is preventing me from reading, but it's from a client who, after 6 months we didn't actually need to issue in this case, haggling, wrangling, any description you like, her partner has agreed to the sale of the property. Now I'd love to read you the email, because she thanks me for my excellent and speedy and pleasant management of her dispute, and she's really overjoyed because we just only a couple of weeks ago got her ex-partner, who's living in Australia actually, to sign off on the sale of the property and bring them effectively emotionally as well as financially bring the relationship to a close. So that's a good success story, but the success story which I want to use as a little bit of a case study for the purposes of putting flesh on the bones of this vlog is a case that completed just a couple of weeks ago. What did get very contentious, we had to go way beyond issuing of proceedings, and it was only in April of this year at a court hearing that the counsel and solicitors were able to get into a room with the clients and hammer out a deal, which I think is excellent, fair for our client, but excellent after 9 months of fear and doubt, etc. And just as a good all-round settlement, and I want to use that as a case study. I'm just going to tell you briefly about the facts, what's obviously maintaining confidentiality of that case. It's basically a lady who bought a property in London 10 years ago and moved back to Sweden, and instructed me on a no-win, no-fee basis to get a share of the property. this may be a familiar picture to you. She was, her ex-partner offered a sum in settlement, they weren't married, offered a sum in settlement that was derisory, let's call it. The proportions are accurate, the sums have just been a little bit more generalised. Offered her around £5,000, she instructed me, we settled for £85,000, and that is how much money she is getting after all the other fees and deductions have come out. And I'm going to come on to those other fees and deductions in a moment. And we settled for not a half share of the property, because he had made more substantial financial contributions to the property over the life of the property. But, you know, a really significant, substantial, probably around about 30% of the value of the remaining equity in that property. So she's a very happy lady too. So there endeth the plug. Now I'm going to come on to the three key areas. Now, the very first thing to note, really, and this is a shadow that's cast, a dark shadow that's cast long over the litigation landscape, and it is court fees. Now, here's a really interesting fact a lot of people are simply unaware of, and that is that a year ago, government changed the law, quite an arbitrary point of legislation, perhaps just in order to find money and make budget cuts in the civil litigation system, in the county court system. They really they substantially increased the fees, the court fees that a claimant is required or a counter-claimant is required to pay when they issue proceedings. Now, as we know, this is absolutely critical. If you are sitting there watching this video, you want to bring a claim against a proposed defendant, and you are worried about taking that step from basically non-contentious negotiations and discussions to a contentious phase, and you're worried about the cost implications of that. Let's say if you were to do it on your own with no lawyer involved. Now, I've put underneath a table of some guide table. Remember, these things can be out of date, so remember this vlog was recorded on 31st of May 2016. General caveat, this is general information only. You do need to do a bit of research yourself and apply it to the individual facts of your case. With that aside, you can see how substantial from that chart legal fees are. There could be 5% of the claim value, and in a typical case, let's take the example of the Swedish lady I've just mentioned. You're looking at 5% of a claim value of, let's call it 100,000. That's 5,000. Often it's going to be a lot more. Let's say it's a £200,000 claim value. That's £10,000. You've got to find £10,000 just to get the ball rolling and get your opponent to sit up and take notice. Yeah? I don't know what the government was thinking. I really don't know what they were thinking, because previously it was like £500, £1,000. That's the sort of fee. Fine, you've got to find a bit of money, so that keeps you honest about you having merit in your claim. But to have to find £10,000. So the very first thing that you need to be alive to is the court fee. And how is that going to be paid? Well, you may be in the situation of having already instructed solicitors who's told you, look, Mrs. Bloggs, we can no longer really help you if you cannot now afford to pay much higher rates of our fees, as well as disbursements, as they're called. Those are really anything other than the solicitor's hourly rate fees. Now, I will answer that question but in the round, if you don't mind, and I just wanted to at the outset explain how a no-win, no-fee deal or retainer works. Now, what in reality, as far as you're concerned, it means that in order to do the work, the solicitor's going to want to take a cut of your winnings, commensurate with the risk that's involved in him not being paid if he loses the case, and also having to wait perhaps a year, perhaps longer, to be paid. And law firms struggle, and that's why most law firms don't find no-win, no-fee work attractive. They struggle to cash flow no-win, no-fee litigation. Most businesses get paid within 60 days. In this case, this is going to get paid 1 to 2 years later. So that's why you have a contingency fee, and it's commonly around about 25%, depending upon the risks. It could be as low as 15%. I offer a deal where if the matter settles very quickly, and I've not done much work, the client gets away with a 15% deal. But if it's a high risk piece of litigation, it could go all the way up to 40%. But I tend to encourage people to think about a 25% loss of their winnings as and when they win their case, or as and when the case settles. So now, I won't go into the detail of that because I've made a slight inaccuracy in calling it a contingency fee. It's actually the lawyer's success fee, and you can look at another vlog about success fees. But they're basically the idiosyncrasies of the system in England and Wales means it's a success fee, and it's not quite the same as the American system where you're just simply signing up to part with a percentage of your winnings. It's not quite that simple. But don't worry about it, that's for the lawyers. As far as you're concerned, you are looking at parting with around about 25% of your winnings. Now, we come on to other areas of costs. We have after the event insurance. So let's call that the second item of cost. You've got the no-win, no-fee contingency fee cost. You've then got the costs of insurance. Now that's called after the event insurance, and that's insurance you have to pay for. Well, you don't have to take it out if you feel particularly strongly about your case, but in the non-personal injury sector, you're probably going to want to look at taking out after the event insurance. Basically what that does is that protects you in the event that you lose from having to pay a whopping bill of your opponent, because that could deter you from even, getting the ball rolling from day one if you're likely to be faced with, and they might instruct a high-flying set of lawyers. And I saw a news item about the cohabitation property dispute in which the judge made an order of £100,000 legal costs against the other part, against the losing party. So you need to take out insurance. Now that will, that could be, I've got the figure of £5,000 to £10,000 in my mind. It depends on the value of the claim and the risks involved. But again, you've got that bugbear, as it were. Be checking that your no-win, no-fee solicitor, is actually helping to finance, or is entirely or part financing that insurance to protect you. The next item of cost is sort of general disbursements, which include things like counsel's fee. Often the best barristers won't work on a no-win, no-fee basis. The solicitor instructs the barrister to go to court, wear the wig, wear the gown, do the business. He's the court specialist, he's the specialist in your area of law. He often won't be doing it on a no-win, no-fee basis. He wants to be paid. Who's going to pay for his bill? You may have initial hearings, you may have, you may actually have to go all the way to trial, and that could be quite expensive. You also may have other little bits of court fees along the way. So you've got these three categories, and really they are costs that can't be recovered from the other side. That's the after the event insurance. The law says you can't recover that from the other side even if you win. And the 25% success fee or contingency fee that I've talked about, you can't recover that from the other side if you win. The disbursements, barristers' fees and court fees, I've already mentioned the court fee, which could be as high as £10,000, that you can recover from the other side if you win. So how does it work? Well, a solicitor, and perhaps I will start to wrap up and draw some conclusions, because it does look rather like a scary situation. You're going to a solicitor, he's not charging you for his hourly rate, but then you subsequently discover, well, you discover almost from the outset there's a whopping great big court fee. You discover that he may want some money from you to deal with counsel's fees and other court fees. There may be an expert involved, so you may need fees there. Someone to value the property, for example. And then you may have, so you've got basically a range of fees that need to be that need to be cash flowed. So what does the solicitor say? Well, hopefully he will say he will assist with the cost of those disbursements. He will try and ensure that you don't have to finance and cash flow them yourself. So that's the way that I work. I actually take a financial risk in assisting you in cash flowing those items of litigation. So it sounds as if it's a bit of a plug again. But I think you do need to clarify with your solicitor. It's not going to be a one-size-fits-all. It is going to depend upon the individual circumstances of your case. I, for example, because I don't like a free lunch, I'm not going to entirely, and for other legal reasons, I'm not going to entirely finance these three categories of cost. I am going to want you to put some money down initially. I also don't believe in the principle of a free lunch, so I think that I want my client, I'm taking a big risk that the case is a strong one and that we've got the evidence to back up what you're telling me and that what you're telling me is honest. So I require clients to put money on account. Now you're going to ask, well, how much? Well, in the case that I've just been telling you about with the Swedish lady, she paid £1,500. She paid it over a period of time to take the sting out of it, and then when it became clear it was going to become even more contentious, she had to cough up another £1,000. Now that's quite low. I think I've probably been justified in asking her to put in £5,000. Now those fees, in this particular case, she hasn't got that money back. That's sunk costs. But often, in a lot of cases, if we're successful, those costs will often be refunded. The reason is because I had to do a lot more work, basically costs that I wasn't able to recoup from the other side because of the jurisdictional issue overseas, and I just had to do a lot more work. So, but generally, you can look on. Let's say you're looking at a case worth of £100,000 equity in a property. You might want to look at trying to find upwards of £2,500, perhaps even as much as £5,000. Most lawyers hopefully will be sensitive to your financial situation. You can get a waiver on court fees, for example, if you're in a very difficult situation financially, but not the other items of cost. So you want to, most lawyers hopefully will be flexible, and if a person is struggling financially, I will often try and find a way to make the, take the sting out of it. I could take a bigger percentage of your winnings, for example, in order for cash flowing and paying for more of your costs, more of the cost of litigation. Now, don't be despondent, and just wrap up this vlog now. Don't be despondent. It is, I'm having a sip of my coffee. I've run a lot of these cases. I must have a 75 and 80% success rate with these cohabitation property disputes. The opponents have paid the court fees eventually, and they've paid my barrister's fees. And actually, in this case, I've managed to get away without paying for after the event insurance at all, because it didn't get all the way to to trial. So don't be despondent. The main thing is to remember that you need to instruct someone whom you trust and who's explained cost situations to you clearly, and you need, above all, once you've spoken to your solicitor, perhaps for a little bit of money on account up front first, and he's convinced that you've got a strong case, you've got to be prepared to go the distance. The pair of you, it's an entrepreneurial endeavour between the client and the solicitor. You've got to be prepared to go all the way to trial. And you've got to share the risks. The solicitor will take on most of the risks in the no-win, no-fee agreement, but you'll have to take on a little bit of risk. And in return, you've got to share some of the upside, some of your winnings upon success. Okay, well, do please feel free to comment or email me at the below address if you have any further questions. Don't hesitate to email me or phone me at redwoodlegal.co.uk, www.redwoodlegal.co.uk. I usually am able to speak to clients in person. Many thanks and goodbye for now. Good luck with your claim.